Because of a partial award by the tribunal, in the course of the case, the parties' incentives flipped during the course of the arbitration. And the claimant then had an incentive to minimize the valuation, and the respondent, conversely, to maximize the valuation. And sure enough, the expert reports came in with, and if I were telling you this as fiction, one might not believe it, but it's fact. The experts' reports quite literally adopted one another's previous positions. And there was a very substantial difference on the order of 100%. There was a very substantial difference, and there was a lot of money at stake.
It's a great pleasure to welcome Gary Bourne to the podcast. Professor Bourne is widely regarded as the world's preeminent authority on international commercial arbitration and international litigation. He is the chair of the International Arbitration Practice Group of WilmerHale. Mr. Bourne has published numerous leading works on international arbitration, international litigation, and other forms of dispute resolution, including the book International Commercial Arbitration, the Leading Treatise in the Field. Mr. Bourne has taught at universities including St. Gallen, where he's an honorary professor, as well as Harvard, the University of Pennsylvania, the National University of Singapore, University College London, and numerous others. There are very many other accomplishments worth mentioning, but I'll leave it at this. Professor Bourne, welcome to the podcast.
Thank you so much, Heiko. It's both a pleasure and a real honor to be here with you this evening.
I'd like to begin with big picture. You write in International Commercial Arbitration that forms of dispute resolution resembling arbitration have a long history, and that they can be traced back to at least Egyptian mythology. That's a long runway. If we look at just the past 30 or 40 years, you've probably seen more arbitrations than anyone else on the planet. When you reflect on that experience, both as counsel and arbitrator, how has arbitration evolved over that time?
That's a great question, Heiko. And I'll answer both the 50-year time frame, but also spend a moment on the 5,000-year time frame. And the reason I do that is because, perhaps oddly, despite the passage of both 5,000 and 50 years, respectively, many of the fundamentals of arbitration, international arbitration in particular, have remained largely stable. It's rather extraordinary to think about it this way, but for literally thousands of years, men and women have been resolving their disputes, especially their commercial disputes, by, instead of going to state courts or local rulers or administrative agencies, going to people that they choose, often experts who they choose, to resolve their disputes in a binding way. And that, frankly, is the essence of arbitration. We can see evidence of that going back to literally 2700 BC, but also continuing up through both antiquity, the Middle Ages, and most recently the last years of the 20th century and the first decades of the 21st century. The fundamental nature of arbitration, and in a sense commercial arbitration, where each party chooses unilaterally according to their own disposition an arbitrator. The two arbitrators thus chosen select a presiding arbitrator, who then, together with the co-arbitrators, hears the parties' dispute and their witnesses, both fact and expert, and makes a binding award. That fundamental paradigm hasn't changed very much at all. Despite that, of course, in the last 50 years, and perhaps in a sense, even more so the last 20 years, there have been important changes to that paradigm. 50 or so years ago, perhaps 70, if you'll indulge me just a second, the New York Convention really fundamentally changed the playing field although parties had often used international arbitration, as I've said, for centuries before. The New York Convention, a global constitution for international arbitration, made international arbitration agreements and awards effectively enforceable all around the world, subject to limited exceptions. And that, I think, really gave a kickstart, a boost to the use of international commercial and also in investment arbitration, at least in some contexts. More recently, the model law similarly encouraged the use of arbitration, but again, by making it more enforceable, hence more reliable. In the last 20 years, I think one's seen both technological developments. COVID brought with it remote hearings, a little bit like what we're doing right now, except with a tribunal in different parts of the world and witnesses and lawyers, experts in different parts of the world. One has seen pressure for what sometimes is called reform, what others might call regression. Calls for greater transparency, calls for appellate mechanisms, calls for other changes to international arbitration. I think a fair number of those have fallen by the wayside or been adopted in a fashion that tinkers, in a sense, with the fundamentals of arbitration. But I think the short answer to your question is, although there have been those changes, to a striking extent, arbitration has not changed in its fundamental character, for the simple reason that businesses and also states have continued to value it, not necessarily because it's perfect, it's not, but because it's better than the alternatives.
Thank you. I would like to get your views on experts and expert testimony. Now, expert testimony may not have been around quite as long as arbitration itself, but documented use of expert assistance dates back many centuries as well. And over the course of your career, you must have observed experts of all kinds: quantum, technical, forensic accounting, industry specialists, legal. Can you paint a picture of the state of expert evidence today as you see it? Are you generally satisfied with the quality of the work? Do you see any notable trends?
I think you're exactly right. Expert testimony has been with us for a very long time, and I my own personal view is that it is in most cases invaluable to the tribunal's proper consideration and decision of disputes. Today's world is at least from our perspective measurably more complex and technical than the world in 2700 BC or 1200 AD or even 1950. And to appreciate that complexity, not using ChatGPT, experts are essential to the tribunal, also frankly to counsel in understanding what a complicated commercial field is, a complicated technical problem is, and how best to both present that and also on the tribunal side to decide it. It perhaps is unexciting for me to say I'm largely satisfied with how experts both are used and how they perform. Obviously, no expert is perfect. Obviously, some experts make mistakes or opine on things that they shouldn't opine on because they lack experience or because they lack a proper factual foundation or for some other reason. But by and large, in my experience, experts today, often more professional and experienced in that role than historically, contribute very substantially, perhaps immeasurably, to the arbitral process. I know that's true in the international context, where, for example, you have highly complex engineering or financial issues, and having someone correct the predispositions that lay people, the tribunal, frankly, inevitably bring to a technical issue is in my view essential. I don't have significant issues or complaints about the process that's often used, namely expert reports prepared together with counsel, presented to the tribunal and of course to the opposing party, answered by detailed expert reports, and then either with or without reply reports, an opportunity to question experts about all aspects of their report, everything from experience to assumptions to calculations. I think in a sense, the development of techniques like hot tubbing, which I think actually works best with experts as opposed to with fact witnesses, contributes also to the benefits that expert testimony bring to a tribunal. In a perfect world, perhaps one might try to imagine some different means of presenting expert testimony, and I know various practitioners have their pet projects on that. In my own view, if it ain't broke, don't fix it. And certainly, if you do try to fix things, make absolutely certain that the remedy isn't, in fact, something that hurts the patient more than the alleged malady. For the most part, I think the evolution over the past, in my experience, 25 years or so, of experts into, if I can put it this way, much more professional experts, people who are trained so that their primary occupation is acting as an agent, as an expert, sort of understanding the process, bringing their expertise in the most focused and understandable way to quite experienced tribunals, but ultimately non-expert tribunals, has actually been a real benefit, which has been augmented by some of the additional procedural devices, whether it's hot tubbing or the IBA rules and taking of evidence and the like.
Great. I'd like to get your views on expert specialization. So in Europe, including in the UK, it's very common for quantum or forensic accounting experts to be generalists, even though if you think about it carefully, accounting and valuation are really quite different disciplines, but they're often performed by the same experts. By contrast, in the US, an expert can be doberted, and that pushes experts, as I understand it, to a narrow specialization. Do you think that's a better approach, or is the European model preferable in your view?
I think that's a difficult question to answer. I've had experience, perhaps fortunately, perhaps unfortunately, with both models, and I think I don't see a particular reason that the U.S. model makes sense outside of the specific context of U.S. litigation, where because of jury considerations and a desire to avoid confusing or misleading a lay jury, when needs more guardrails in a sense. I think the real question is, are generalists able in a useful, persuasive way to address whatever the issue before the tribunal is, with the tribunal, perhaps unlike either many or all juries, able to assess possible shortcomings from a generalist background, or alternatively, I've seen this in some cases, possible benefits from a generalist background. And in those circumstances, if counsel who hopefully know the case better than just about anyone in the world think that a specialist is better suited to present a particular expert issue, they presumably will use that, and I've certainly seen that done in non-US contexts. But if they don't think that's either necessary or arguably in some cases the best way forward, they won't. And as a consequence, a bit like arbitration procedure and evidentiary questions in arbitration more generally, I think the flexibility and adaptability of international arbitration with a tribunal that's able, while admitting evidence to weigh its credibility and assess its proper weight, um, is ultimately more desirable than a process that mandates a particular type of presentation, which I believe is the case in the US.
Yes, thank you. I'd like to pick out one trend of the last perhaps 40 years, which sits at the intersection of questions of law and other disciplines. So I've observed that many courts and tribunals recognized only really over that time frame that there can be disciplines like financial economics that can be central to assessing damages. So as an example, Delaware granted shareholders fair value appraisal rights in the 1960s. But it wasn't until 1983, as I understand it, that the Delaware Supreme Court allowed evidence based on modern valuation methods. And since that year, the court's views have evolved quite significantly. The court has engaged with concepts like asset pricing, market efficiency, even control premiums. And while perhaps not perfect and at times quite heavily criticized, the trajectory overall seems broadly positive, it seems to me. And I wonder what's your take on this and why this has taken so long?
It's a great question. I think, and perhaps it's predictable, I would say this, but in a sense, it reflects one of the reasons businesses prefer arbitration, especially international arbitration, to litigation. Courts inevitably have regard to precedent. It's one of the benefits of the judicial system. We have decisions that state particular rules of law or how you approach particular issues. And part of the benefit of a rule of law is you have stability and predictability. And therefore, if a particular approach towards valuation or some other aspect affected by expert testimony is adopted, courts will hesitate to not apply that. They'll hesitate to not apply that because in US parlance, it's stare decisis. We've already decided how to evaluate these issues, and we're not going to change because that would upset people's expectations and so forth. Arbitration doesn't have the same devotion, if I can put it that way, to stare decisis, and in particular the arbitral tribunal. Part of the reason parties agree to arbitrate is exactly to obtain the expertise both in a commercial sector, but it also expertise with respect to evaluating financial accounting, valuation, other issues, but not just that, also how you test the reliability of a particular joint or a particular compound used in a pharmaceutical product. And I think, although I wouldn't want to overemphasize it, I think the inevitable flexibility of a tribunal focused on a specific problem between two businesses here and now today inevitably makes it more willing to look at modern techniques, or whether it's financial accounting, valuation on the one hand, or metallurgical or computer science developments, may have changed the reliability of previous authorities, made stare decisis less than the dominant concern. And as a consequence, I think it is understandable why it would take courts some decades, and it likely doesn't take arbitral tribunals quite so long.
I can see a kind of healthy evolution in the Delaware cases of appraisal rights, it can feel at times as though a similar evolution is somewhat absent, almost absent in some parts at least of international arbitration and litigation. Some tribunals are extremely well informed. Others barely engage with matters of financial economics at all. Perhaps the reason might be that those cases are less streamlined than the appraisal rights cases, or there may be some other reason. So if you agree with my premise that this is less than ideal, what could be done for tribunals to engage far more with what we've actually learned from financial economics? Is part of the answer perhaps a routine use of court or tribunal-appointed experts, or something else?
It's a great question, Heiko, and a fascinating topic. I agree with your premise, although I would note that the example you give, the only example you give is a high court judgment, not an arbitral award. And my experience has been hopefully a little bit different. I have seen tribunals, arbitral tribunals, generally not prepared to come up with, in a sense, their own expert calculation, but in part because of the importance of not having surprise decisions and basing your award on what it is that the parties, and including the parties' experts, have presented. Instead, often a choice of one methodology or another. Now, they may not accept some factual assumptions, change the factual assumptions, but effectively they would use one party's model or another party's model, or in some cases they would instruct the experts to go off and jointly come up with a model that they're happy with. I strongly agree with the proposition that neither courts nor arbitral tribunals ought to put themselves in the place of either corporate finance academics or corporate finance professionals or corporate finance experts. I think the tribunal has legal expertise. It has a mandate to evaluate both the facts and the expert evidence, but probably reinventing quite poorly corporate finance, or for that matter, other technical financial accounting and principles, seems to be a very bad idea. Also something that would expose, at least absent careful discussion with the parties, to challenge either an annulment or recognition proceedings. I believe that the best way to avoid this is for the experts to make clear, the parties' experts, to make clear to the tribunal the academic literature that bears on a particular issue. It doesn't have to be the specific one that the example that we have, cash accrual or some other kind of accounting principle. But tribunals are not deaf to that. I've certainly been on tribunals where careful regard has been given to academic literature that cited too. And tribunals are, they're certainly not experts in the field, but they are both prepared to try to understand that and, frankly, to be deferential to those who know better. I'm less convinced, I have to say, by the notion of a tribunal or a court expert. I worry both about expense on the one hand and to some extent delay. Inevitably, you need both appointment process. You need to then have parties and their experts commenting on what the tribunal experts said. I worry a little bit about delegating, in a sense, the tribunal's authority to a third party, even if it's an expert. My own view is, and I've seen this outside the context of financial issues or accounting issues, tutorials for a tribunal where the amount in dispute warrants it. I've seen in patent cases tutorials on the science behind a particular disputed patent, or why it is a claim in a patent must cover and must not cover a particular product. And tribunals, I think, are quite open to a tutorial that basically, we teach them about the financial accounting issues, valuation issues that you raise. Obviously, the amounts in dispute have to justify the expense for that, but equally obviously, in a fair number of cases, that is true. We wouldn't be talking about it otherwise.
Thank you. I'd like to move to the output experts produce in arbitrations. And to give some context for our listeners, my starting point is that expert work is usually not like solving a math equation where 10 mathematicians would independently arrive at the same result. In expert work, the outcome typically reflects a combination of instructions and then expert assumptions. And there's very often an element of expert discretion, which can lead to a wide range of outcomes, sometimes to the point of two ships passing in the night. Could you talk about approaches tribunal can adopt to address the issue that expert reports do not really engage with each other, such as expert conferencing, or more recently, perhaps a joint expert meeting before the first report, or other measures?
So I can answer this question in a sense with two hats on. But most of what I do in life is act as counsel, instructing experts, cross-examining experts, and the like. I also, though, act as an expert, a legal expert, not an accounting expert, a legal expert. And I can emphatically agree with your observation that experts on the same issue, equally qualified, more or less equally qualified, equally experienced, more or less, pass in the night and also arrive at utterly different destinations. Sometimes because of assumptions, but sometimes because of different judgments about particular aspects in their field of putative expertise. I think you have already identified some of the most important ways that one can try to address that. Firstly, good cross-examination and good questioning from the tribunal. Insofar as it is assumptions that drive differences, and with accounting experts, for example, damages experts, that can often be the case. Those different assumptions can be identified. If you use one interest rate or one sort of future sales or revenues, then you're going to get a very different conclusion than if you use a different one. And good cross-examination, good questioning from the tribunal can do that. If a party doesn't avail itself of that opportunity, in a sense, that's an inevitable result of an adversarial process. Doesn't necessarily reach a perfect result. It reaches a result that fairly resolves the dispute presented to it by the parties. And if they haven't presented it in a compelling way, if they haven't identified the faulty or incorrect assumptions, then inevitably they won't be as happy with the result. I also think experts, in addition to the first report, have a reply report, and one sees this very frequently. Those reports can call out improbable or unlikely assumptions, as well as other aspects of a flaw in the opposing expert's report. I'm less convinced about the usefulness of joint expert reports. It's certainly something that it can be done, and it is, in my experience, relatively easy to do. Obviously, there can be procedural hiccups, but it doesn't take massive amounts of time, and I guess in a sense, it can't do any harm. I have often, though, seen joint expert reports that in some sense aren't really joint. They're just restatements of fundamentally different positions. I I guess I begin from a premise that I alluded to previously, which is for the most part the existing system, um, uh, subject to my comments about the adversarial process, works reasonably well. I think it works best when you have an arbitral tribunal that is deeply engaged and prepared itself to be able to evaluate the assumptions and the judgments and the like.
Thank you. The challenge, of course, isn't just that experts reach different conclusions, that there's noise. It's that those conclusions often strongly favor their side, sometimes in extreme ways, so that there's bias. And to give some background, expert work typically involves a series of assumptions or expert decisions. We can illustrate this here with this graph. Each decision may allow some discretion to the expert. For example, if I calculate the cost of capital, I might need to estimate a risk-free rate, a beta factor, a market risk premium, and so on. And that's just for the cost of equity. So in total, there can be dozens or even hundreds of individual decisions, each often with some discretion around it. And what I observe is that bias accumulates through the sequencing of these discretionary choices. So even if each decision falls within an acceptable range, when an expert exercises the decision at one extreme end of the range, always the same extreme end of the range, then the overall result can become highly skewed. And that idea may seem theoretical and far-fetched at first, but something like that is, I think, exactly what happens very frequently in expert work. And the outcome of this aggregation is an expert estimate that is often far beyond any reasonable range. Yet a tribunal might not be able to point to a single assumption that falls outside of its particular defensible range. So the issue is really the sequencing of discretionary choices. And for a tribunal to uncover this, it would really need to unpack each individual assumption, understand the acceptable range for each, and then identify where discretion was exercised. And that basically almost never happens. And so the result can be a race towards extremes between experts. And I'd be very interested to hear your thoughts on this dynamic, whether you've observed this and what can be done about it from the perspective of a tribunal.
So the short answer is I've absolutely observed. I'll recount one episode in just a moment, and there are mechanisms for addressing this, both in larger cases and to an extent in smaller cases, and I'll try to say a word about that. I was an arbitrator in a case some years ago where at the beginning of the case with two quite well-respected expert firms on either side. The claimant had an incentive to have as high a possible valuation as it could, and the respondent had, unsurprisingly, the opposite incentive. And they both put in extremely detailed expert reports that were meant to validate their respective valuations. Because of a partial award by the tribunal in the course of the case, the parties' incentives flipped during the course of the arbitration, and the claimant then had an incentive to minimize the valuation, and the respondent, conversely, to maximize the valuation. And sure enough, the expert reports came in with, and if I were telling you this as fiction, one might not believe it, but it's fact. The experts' reports quite literally adopted one another's previous positions. And there was a very substantial difference on the order of 100%. There was a very substantial difference, and there was a lot of money at stake. And therefore, I fully agree with your premise. And there was, of course, nothing facially wrong with any of the four reports. All of them used a variety of assumptions, and a little bit, I thought the way you put it was quite elegant, with just some assumptions that on every one of multiple issues, maybe weren't at the extreme edge of the spectrum, but we're in substantially in that direction. Each is able to come up with, without any change in the relevant factual circumstances, with completely the opposite valuation. There is inevitably a risk of that. I'm not sure I'd say it's biased. Perhaps it is biased. I think it's the inevitable result of an expert being unilaterally selected and paid by one party, instructed by one party, working closely with both that party and its counsel, and natural human inclination to try to defend your report. You've filed it. Perhaps that's biased. So what is it that tribunals can do faced with this tendency on the part of at least experts in some cases to use their discretion in ways that ultimately produce an exaggerated result? In larger cases, I don't think it's at all unrealistic to expect opposing experts to call out their counterparty and say their judgment depends on 12, 15, whatever the number is, key assumptions. They have used their judgment, and you can imagine a chart or a graph, series of graphs that shows this in every single case to produce a result that cumulatively is implausible. You can see how they have used their judgment at the extreme end or near the extreme end, and perhaps you don't accept mine, which perhaps is on the opposite end of the spectrum. But it's implausible to think that each one of these multiple issues ought to be resolved in that way. And tribunals can then judge each one. Maybe in some cases, it does make sense, in fact, given the circumstances, to have an extremely high discount rate or an extremely high, projection of future revenue or whatever the assumption is. But the tribunal can go through and make granular judgments with the guidance of opposing experts as to how all of these assumptions don't make sense, and therefore requires a recalculation. Obviously, tribunals can instruct experts. I've done that to recalculate something. I've had tribunals when I'm counsel instruct not my expert to do that. And where the amount in dispute warrants, I would have thought that largely addresses the issue. I think a bigger problem is in smaller cases where spending that kind of effort and that kind of money may be prohibitive. And this relates back a touch to the bigger cases. The world being what it is, some tribunals may be inclined in some cases to do what in biblical and contemporary vocabulary is called splitting the baby. If one expert says, the appropriate rate is 1% of whatever, and the other expert says the appropriate rate is 11%, you can tell me where the median is between those two. And tribunals may end up there, especially in a smaller case where they get less presentation, less information on which to make individual assumptions. And perhaps that's not a bad approach. Perhaps that does justice, maybe only rough justice, but justice in most or all cases. I worry a bit in the larger cases that's too back of the envelope, and that in a sense splitting the baby may drive the experts to even more implausible judgments, and because they expect that to happen. In my experience, in larger cases, that doesn't happen. Tribunals are alive to the notion and don't want to be seen to be just splitting the baby or adopting an average between the two parties, but it's certainly a natural human tendency and a bit of a risk.
Great. Yeah. But I want to come back to the idea of splitting the baby. And I just want to put another scenario to you that's kind of a dilemma for experts. And if we assume, just for the sake of argument, that there are two independent but party-appointed experts, say A and B. And let's assume, we can see this in the visual, expert B positions themselves at one end, an extreme end of a range of outcomes, here on the right. And expert B is now faced with the question where to position herself. Let's assume B is aware of expert A's bias, and A knows that B is aware, but it's unclear whether the tribunal has the information to unpack all of this. And so one option for expert B, especially if there's an idea of splitting the baby, might be to also move to an extreme end of the other side of the spectrum to counter A's positioning. But let's assume B is an expert who takes her responsibility to the tribunal seriously. And then the thing turns into a communication problem in some sense. How can B convey to the tribunal what's really happening here? All the tribunal sees is the positioning of the two experts, the two data points of two experts. It does not see the true value, if you will. And whatever expert B tells the tribunal about expert A's bias, A may well allege the same about B's bias. And all the tribunal sees is two data points far apart. And let's assume expert B does not really wish to engage in these kinds of positioning games, but at the same time, she recognizes the realities of the situation and the behavior of expert A and of arbitration more generally. Do you have any advice for her?
Well, this is not an issue that is unique to experts, much less to Ms. B and Mr. A. It's an issue that confronts counsel all the time. What do you do if your opposing counsel is extraordinarily aggressive on all aspects of the case, procedural requests, allegations about the facts, legal arguments? Do you respond in kind, or do you take a more an approach more like you suggested Ms. B, the expert, would take? Inevitably, in any adversarial process, whether it's counsel or expert witnesses, that is a dilemma that one needs to address. I believe that also is why it is so important to wisely select arbitrators and participate well in the constitution of the arbitral tribunal, because one ultimately wants a tribunal who, when, as I often conclude is the best course, is confronted with Ms. B, who is scrupulous and diligent and, if not independent, at least faithful to her discipline and her expertise and what the facts are, and Mr. A, who, for whatever reason, isn't, will perceive that, will understand that B is offering her genuine best judgment, and that best judgment, although not necessarily correct, has more credibility, is better grounded than Mr. A's conclusion, and will therefore, although he or she may not accept what Ms. B's assumption or ultimate conclusion is, will weight it more highly, significantly more highly than what Mr. A has said, and in particular, will not split the baby, whether mean or median, average, or something else between B and A, but will instead, and this really is where an independent tribunal is important, will come to correct the correct view of that particular issue is. I've seen tribunals do this. I've seen tribunals both as counsel and sitting on arbitral tribunals. I wouldn't say disregard, but heavily devalue a particular expert's view about either specific issues or their entire report because they've done what you outlined, and have instead, while perhaps not accepting entirely the opposing report, sometimes have done so, but also sometimes have based their conclusion largely on that with some tweaks.
Great, thank you. I'd like to switch gears a little bit and ask for some career advice. And this is a question that actually came in from listeners ahead of the podcast. Now, Gary, you've had more successes in disputes than anyone, but you must also have faced setbacks and disappointments along the way. And I'd like to ask two questions. What lessons do you have for the rest of us who will likely have a much lower batting average? And how would your answer have been different 30 years ago?
Those are two great and difficult questions. You would make a good tribunal member. I'm not so sure about my batting average. One of the difficulties with being recognized as leading advocate or counsel is that people come to you with their hardest cases. But on the assumption that I can bat reasonably well and that my advice therefore is worth listening to, I think the most important bit of advice that I can give is treat every opportunity. That means every pitch for a new case, every representation of a client, every cross-examination, every written submission, as if it were the most important opportunity in your life and that it's the only one you're ever going to get. Even if it at the time doesn't seem so important. There may be circumstances where, because of the economics of modern expert and legal firms, one can't spend the amount of time that one would like, but insofar as you can, my advice would be both spend that time and, in a sense, more importantly, spend that emotional energy, that commitment. And the reason I say that is you never know in your career which successes and also, frankly, which failures will in fact lead to more opportunities. The best way to develop future opportunities, and putting it really bluntly, future business, is by doing well existing business and by doing as much of it as you can. This advice is not particularly good for work-life balance advocates, but in terms of creating exciting and interesting and perhaps less importantly, rewarding opportunities in the future, seizing every opportunity that does come along and treating it like it's the most important thing, and you absolutely have to get this case, you absolutely have to nail this cross-examination, you absolutely have to write the best possible letter here on this procedural issue. My advice is try and do that. That's my advice today. My advice 30 years ago or so might have been largely similar, but without much to validate it. Advice I give today really is based on experience, and I probably would have been a little bit more calculated 30 years ago, I would have probably said, well, if it's a good opportunity, calibrate your effort, put a lot of effort in it. But if it's a less good opportunity, don't put as much in. Be thoughtful, be nuanced. Um, um, you can never know when an opportunity is going to be good or bad. I don't know how many cases which have turned out quite well I've been involved in because opposing counsel or an opposing party has, when our little dispute is done, have come back and said, well, we'd actually rather have you on our side. And as a consequence, I'm not sure one can really calibrate one's effort, one's diligence very well. And so I would just, whatever baby born would have said, I think you should pay attention to my views of today.
That's great advice. Thanks very much. And finally, Gary, we began the conversation with a historical perspective on dispute resolution over the last 40 years and longer. And I'd like to close with a long-term outlook. If you had to speculate about the next, say, 40 years in international arbitration, in the broadest terms, what do you think the overall landscape will look like 40 years from now?
A little bit like testing the views of a 30-year-old Gary Bourne, except now we've had the benefit of 30 years of experience. It's extraordinarily difficult to say what international arbitration, international litigation will look like in 40 years. I think if one looks at it from the vantage point of this moment, one would be excused for being pessimistic. One would be excused for asking not just whether winter is coming, but whether the ice age is coming. It has the rule of law in international affairs, both public international law between states, but also private international law dealings between businesses either become less important or occasionally when one looks at the newspaper irrelevant. I think it's fair to ask those questions. There's been also, more specifically, much criticism first of investment arbitration, and more recently, perhaps surprisingly, of international commercial arbitration. One hears even asserted proponents of law and international arbitration arguing that it should be fundamentally reconfigured, that one must have variously complete transparency or an appellate mechanism. And looking at the types of asserted concerns that motivate those contentions, I think one can again fairly ask, is an ice age coming to international arbitration? I remain, and I'm right about this, an eternal optimist. International arbitration has survived, as we began by saying, for literally 5,000 years. It's survived the Roman Empire, the Dark Ages, the Mongol invasions of Europe, the various wars of the 20th century, and not just survived, but prevailed and become more popular. I remain optimistic that the freedom of individuals and also businesses to choose, going back to exactly how we began, to choose those other individuals who will resolve their disputes in a final way, is too ingrained in human nature, 5,000 years of human experience, and too fundamental to what I think will ultimately prevail, a rule of law in a society of ordered liberty. And as a consequence, because people ultimately will do what makes them more safe and more prosperous, I think we will continue to have international arbitration with a legal framework, legal convention, and strong modern law, much as it is today. We may have AI assistance or other technological assistance that we haven't foreseen, but that fundamental system will continue in 50 years, not just 5,000 years ago.
That's wonderful. Thank you very much for joining us today, Professor Born.
Thank you, Heiko. This was really fun, by the way.